Let's talk about making a will. A will gives you control over who gets what and can help avoid paying more inheritance tax than necessary. But did you know that without a will, the law decides who gets what? Let's say you have children from a previous marriage and want to ensure they receive a portion of your estate. Without a will, your current spouse may inherit everything, leaving your children with nothing. You can write your own will, but it's best to seek advice if it's not straightforward, and remember, your will needs to be formally witnessed and signed to be legally valid. If you need to update your will, you can make an official alteration or create a new will. Just make sure to keep it up to date with your current wishes, so don't leave it to chance. Make sure you have a will in place to ensure your assets go where you want them to. It's never too early to start planning. Let me explain the rules of intestacy in England and Wales. If you're married or in a civil partnership, your spouse or partner is given the highest priority. They're entitled to the entire estate if there are no surviving children. If there are children, your spouse or partner receives the first £322,000 of the estate, plus personal belongings, and half of the remaining estate. The other half is distributed equally among the children and held on trust until age 18. But what if you don't have a spouse or children? The estate follows bloodline, so it will either go to grandchildren or go up the chain to your mum and dad or grandparents. If there is nobody that can inherit it, goes to the Crown. This is known as bona vacantia and is administered by the Crown as the last resort. It's important to note that the rules of intestacy do not consider relationships outside of the family, such as close friends, without a valid will. These individuals will not inherit from the deceased's estate. Sorting out an estate without a will can be a bit more complicated. If there's a relative or friend who is willing and able to sort out the estate, they can apply for a grant of letters of administration. This makes them the administrator of the estate. Sorting out an estate without a will usually takes more time. The sooner you apply for probate, the sooner you can distribute the estate to heirs. Using a solicitor or probate specialist can make the process of sorting out intestacy easier and a bit quicker, but you should budget for several £1,000s for their services. If you decide to take on the job of administering the estate, you can still pay a solicitor for their time. The process of sorting out an estate without a will is almost the same as when there is a will. It's important to understand the intestacy rules, because the law decides who inherits the estate according to certain criteria. If there are no surviving relatives, the person's estate passes to the Crown. Did you know that half of UK adults don't have a will? This means they will pass away, intestate, and their assets will be distributed according to strict inheritance laws. The rules of intestacy don't account for modern family relationships. Unmarried and unregistered partners, stepchildren, and distant relatives may not be recognized as beneficiaries. Just a quick reminder before we proceed. Please remember to hit the like button. Also remember to subscribe to the channel and hit the bell button so you get all the notifications about upcoming videos. In May 2023, the average UK house price was £285,861. Without a will, a married couple with children owning a house solely in the name of the deceased would result in the spouse receiving £270,000 and the remainder divided between the spouse and children. However, with the new statutory legacy, the surviving spouse can receive the entire value of an average house. This eliminates the need to sell the property, making it advantageous for individuals who have failed to create a will. But what happens if there is no will? If there is no spouse and no children, the estate is split between surviving parents and then siblings. Cohabiting couples have no automatic rights to inherit anything from each other. It is essential for cohabiting couples to create a will to avoid a complicated and expensive court process. Don't leave your loved ones with the burden of intestacy. Create a will today to ensure your assets are distributed according to your wishes. The most entitled person can apply to become the administrator of the estate. This is usually the closest living relative, spouse, or civil partner, followed by any children 18 or over. If you're not the spouse or civil partner, you cannot apply to administer the estate before applying for probate. If you're unsure, speak to a probate practitioner like a solicitor. It's important to follow the legal process to avoid complications. That's all for this video. If you found this video of interest, please give me a thumbs up and subscribe. I welcome any comments or thoughts you can share with others on the topic down below. Remember to consult an accredited professional for specialist advice before making financial, legal, or any other retirement-related decisions requiring expertise. This channel simply shares publicly available information in the UK which you use at your own risk. If you are approached by somebody with exotic-sounding investments and impossibly sounding good returns, you may be about to be duped by a scammer. Always do your research. Stay safe, stay smart. Until next time.